Now let's just go back up. Let's kindly scroll up on this section. Come to para 3. No, I'm sorry. Para
So this is the second point, no, Dr.
This is the
Singh?
second point, but just one thing is left here, para 9. Para 9. I'm not troubling with A3. My submissions A to N are giving the law EBUs, meaningful, status quo ante, scrambled egg, fait accompli. All that is given with law, in that. Kindly, do me the favor of treating it as having stated here. Now, number 10. Indeed, in Bomai, paras, etc. given, the overwhelming majority of 9 judges made it clear that the proclamation under President's rule under 356, there were 2 states involved, Karnataka and Meghalaya, is very important, is liable to be struck down, and the dismissed government is fully entitled to be restored to office. But the only reason we are not doing it because elections have been happened in the intervening period. Now, this is very important. This has not been shown to your lordship. Just give me a minute. 398 and others, 5 judges out of 9 say this. 5. First is Justice Jeevan Reddy with Justice Agarwal. The proclamation must therefore be held to be not warranted by Article 356 outside its purview. Cannot be said that the President was satisfied that the government of the state cannot be carried on. The action was mala fide and unconstitutional. The proclamation is accordingly liable to be struck down. And we would have struck it down, but for the fact that elections have since been held and a new assembly has come in. That's the only exception. Today, the illegal government is running. There is no elections. Then, and the person who otherwise, suppose the lordship holds the governor to be bad, then a person not entitled to be holding the post of chief minister. How can, of all courts, the Supreme Court accept such illegality? If your lordship's powers are unique in this country, in that even your lordship's can go beyond the law. Not contrary to law, beyond the law. Then, what's the point if the governor's actions are held to be illegal? Actually, your lordships would be giving a Parik declaration and accepting that the illegality has borne the fruits of its illegality and people have enjoyed it. Now, let's just see next one. In state of Meghalaya, it's very interesting. For the other state in Bomai, para 12 of my note. Again, Justice Reddy said, but for the fact that since the proclamation, fresh elections have been held to the assembly. So suppose Meghalaya had not had elections and Karnataka had, they would have restored in Meghalaya. We would have certainly issued the writ and directed restoration. Justice Sawant for himself and Justice Kuldeep Singh, our conclusions may be summarized. However, in view of the fact that fresh elections have been taken place and new assemblies have been constituted and all, no relief is granted consequent upon the declaration. Therefore, this is the heart of this point. Now come to page 1 on 189. The third point is 189. All right. That is coming separately. That's coming separately.
What is the point, Dr. Singhvi?
Yes. Now, a very strange argument was raised, de facto doctrine. Regularization and validation by 189. Mr. Salve argued at length. Mr. Mehta also argued.
Page
I believe
189. I'm sorry to interrupt. What is 189?
No, page 1.
Page 1 of my note. That is the de facto doctrine that actions validated by the actual act which is challenged is illegal. I want to show how wrong this can be and how dangerous it is. Give me just 2 minutes. The case law makes it clear, but just come to the case law later. Just give me 2 minutes. The first important thing is to note there are 2 kinds of challenges. One is a challenge to the very validity of the act. Come to para 8 of my note. So I challenge a validity of an act. Let us say the Governor's Act. Let me say competence of a legislation. Let me say fundamental rights. Versus the eligibility of certain people to act under the act, to sit there and act. Your lordship under 189 protects the second, not the first. If the governor's action is bad, will 189 ever protect it, Mr. Learned friends, 2 of them argued at great length on 189. Did they answer the question? Ultimately, the core question, my lord, is just formulated either way, this way or that way. Is the governor valid or not valid? If your lordship holds him to be invalid, 189 comes only after your lordship holds something to be invalid. Otherwise, it doesn't come into play.
It is said in the context of the vote in the House.
So,
with respect to
exactly. So, therefore, no. 189, your lordships can and may, and in this case, perhaps should, in the intervening period of 7-8 months, the decisions taken by an otherwise illegally constituted government may be valid under 189. That's the real commonsensical way of implementing it, fellas. I am not suggesting that somebody's appointment is quashed, somebody's transfer is gone, somebody's policy decision.
So what you're
Maharashtra
really
government has
saying
made a
is,
liquor policy,
Dr.
therefore
Singhvi,
that
what
is
you're
gone.
saying is that Article 189 recognizes a de facto doctrine.
De facto doctrine.
What the de facto doctrine does is to legitimize the acts of a authority whose original appointment is found to be invalid.
Subsequently found to be.
Subsequently found to
Correct,
be invalid.
correct.
But that does not validate the original appointment
That's
itself.
that's the one sentence pithy summary. Just give me a minute. Come to D, 8D. 8D. Or calling for, that goes back to the same thing, Wallace. First act was what? The governor being approached, governor calling. The two others are consequences. Voting is a consequence of the governor's illegal act. So is the oath taking. If the original act is bad and your lordships can't validate it, then this will not validate the vote, Wallace. The consequence is bad. The consequence of an illegal origin cannot validate the illegal origin. And similarly, 189 cannot
What you're saying is that if the calling of the voting in the house itself is subject
That's
to their-
just how my lords formulated was, right or wrong. Governor's action, A, no basis, and B, if basis, well, it is wrongly applied, etc.
But that's affirmation of the house, right? Then what? I mean, I still have it.
Affirmation is coming. That's this section. Bommai dealt with the affirmation.
All right.
Bommai said, we hold something to be illegal. Let's kindly give me a minute. This is very interesting. But thereafter, Parliament has approved it. Exactly the same thing. How can we quash it? Said, no, sorry, it will be quashed. Can you come to that now? So first, well, let's come to, yes, I'll just show 350. Just keep 356. Maxima's query answered by Bommai. Para 4 of my note, this note. Much worse, fellas. Here there was nothing, in our case there's nothing. There was a presidential proclamation affirmed by Parliament in Bommai. Now come to Wallace para 4. It is respectfully submitted that the said contention is misconceived, liable to be rejected in Bommai. Does my lord have it, Wallace? Para 4? Do my lords have it?
Yes.
Yes.
Considered the effect of approval of a presidential proclamation by both houses on the legal validity of the proclamation when it is questioned before the Constitutional Court held a clear majority, 5 judges, Wallace, that if a proclamation on 350 is invalid, the same as liable to be set aside even if it has been subsequently approved by both houses. Your lordship is told 189, this is express approval. This is express approval. Now read this para, very interesting. 110, Justice Sawant for Justice Kuldeep Singh.
We'll set this up. We got the point. I mean, you're saying that the Bommai has a.
Now there is one interesting, very interesting, after 29 years and 2 days, this is happening in your lordship's court. This para 110, that bold-face line by Justice Sawant says invalid. Lordship got the second line underlined.
Yes.
All the books say it's valid. SCC. SCR correctly says it's invalid. SCC for 29 years and 2 days called it valid.
I hope you're citing our ESCR, Dr. Singhvi.
No, this is, we've checked up. Then they issued a corrigendum. When my learned friend's colleague here, sitting here, pointed it out, then Wallace, the SCC
Dr.
issued a
Singhvi,
corrigendum.
I must also publicly acknowledge there's a glitch in our ICT infrastructure overnight. My team was working till 5:30 in the morning. They began working yesterday.
Oh, I see.
They left for their homes at 5 o'clock in the morning, 5:30 in the morning, to ensure that we are all
It's very creditable.
we are ICT enabled.
It's very creditable.
And unlike the private sector, they wouldn't get even a rupee worth of bonus. It's just a love for the job that they do it.
The time, money.
Private sector is senior education.
Your lordship is entitled to judicial
Ah.
right, Wallace.
Batao. You are part of them.
No, this is just an aside. The
I was
word
saying private sector or senior councils, I said. The chief is saying.
some of your lordships, most of your lordships.
I told my learned brother, you are
Stop.
part of them too.
Complete estoppel, Wallace.
Estoppel, that's why I didn't.
And a very recent estoppel, Wallace, relatively. Now, Wallace, the word invalid here is by corrigendum, the correct word. It is in the SCC valid. So it can't be valid. Just note that. What is the legal consequence of actions taken by the president if the proclamation is invalid, yet it is approved by both houses? Come to 111 lordship and see I am racing only on the underlined portions. The proclamation will not make any difference to the legal status. Express approval. Forget 189. Parliament expressly approves. The action will undoubtedly be illegal. Then we'll skip 10 lines. There is no reason why the Council of Ministers and the Legislative Assembly should not stand restored as a consequence of the invalidation of the proclamation, the same being the normal legal effect of the invalid action. In the context of constitutional provision which we have discussed, and in view of the power of judicial review vested in the court, such a consequence is also a necessary constitutional fallout. Necessary constitutional fallout.
Get the point.
Unless such result is read, the power of judicial review is nugatory and meaningless.
There is a constitutional permissible, it's permissible to have a complete restitution, is what you're saying.
Otherwise, it's meaningless and nugatory. The 9 judges say that. And next sentence highlighted. Hence, the necessary consequence of the invalidation would be the restoration of the ministry as well as the Legislative Assembly. Then para 114, boldface. Secondly, the court may invalidate the proclamation whether it is approved by Parliament or not. The necessary consequence of the invalidation could be to restore the status quo ante. Therefore, to restore the Council of Ministers and the Legislative Assembly as they stood on the issuance of the proclamation. So, if your Lordship is otherwise convinced, your Lordship needs no support than more than a 9-judge bench, which is very clear. It may, however, to be made clear. Next sentence is very important. Next boldface. It is, however, to be made clear that the interlocutory relief that may be granted on such challenge to prevent frustration of the constitutional remedy. It is not to prevent the constitutional authority from exercising its powers and discharging its functions. And then to conclude, the court in appropriate cases not will be justified in preventing holding of fresh elections, but will be duty bound to do so by granting suitable interim relief. Then, Malas, they summarize the conclusions, which I will not read to save time. Clearly, Malas, para after para is devoted by Justice Sawant and Justice Kuldeep Singh. And Malas, just see 7, another phrase, molding of relief, big Roman 7. Malas, otherwise, what's the point your Lordship is exerting so much, Malas, if your Lordship comes to that conclusion with great respect? And that to a court with 141, 142 and special powers. Malas, I can understand the High Court possibly, Malas, flinching. According to me, even the High Court has the power to do it under your Lordship's judgment. Now, Malas, Justice Jeevan Reddy said this, Malas, even in case the proclamation is approved, it would be open to the court to restore the state government to its power. If this were not conceded, look at these words, Malas, 9 judges, 29 years ago. If this were not the case, the very power of judicial review rendered nugatory, entire exercise meaningless. The court cannot grant the relief flowing from the invalidation. It may well decline to entertain. Well, they say if you can't grant the relief, why did you entertain? That's what this court is saying, 9 judges. And then Justice Pandyan, just 2 lines above 4A. I find myself in agreement with the opinion of Justice P.B. Sawant on conclusions 1, 2, 4 to 8. This includes my conclusions, Malas, which I just read, 4 to 8. So this is, Malas, the 3 points are covered: prohibitory, affirmative, 189, and Malas, resignation. Now, Malas, the 4th point is this, Malas, prospective and retrospective of the EC. They're all important queries which fell from my Lord. My Lord, the Chief Justice asked this question more than once, Malas.
That is C.
That is, Malas, my C. My Lord is right. Pages 8 to 10.
Page 8.
Just, Malas, forget everything else. I'll take one point here is enough. Malas, whatever else your Lordship holds, on the bare text, textually and facially, symbol order number 5, 15, has to be prospective, Malas. Forget all the, we'll come to the interpretation. Just read the text facially. That's at para 15A of my note.
Yes.
Without anything more. We'll come to the consequences. Well, as drafted facially, without any interpretation, it has to be only prospective. Kindly read. Power of the Commission in relation to splinter groups. Now, I've underlined some words. I've taken the liberty of underlining some words. When the Commission is satisfied on information on its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the Commission may, after taking into account all the available facts and circumstances, and hearing such reps of the sections or groups and other persons who desire to be heard, decide that one such rival section or group or none of such rival groups shall be binding. Well, this cannot but be futuro. Number 2, look at the consequences of holding otherwise. There will be, Malas, very, very strange consequences. 2 things, Malas. If your Lordship were to hold the 19th July, that's the date, order of the EC. 17th February 23. I'm sorry, 17th February. Petition is filed on 19th July. 17th February is the order. Now, Malas, the order to be retroactive Question number 1, retroactive from when? There are 3 possibility retrospectivities. Look at the consequence. Well, the Lordship doesn't hold it to be without the consequence. 3. One is, it is retroactive from the date the Shiva Sena was recognized as a 29A political party. That was in 1990 or 92. I'm giving you 3 alternatives. I'm not... because today I am the Election Commission, I hold that this is the Shiva Sena. If it is retroactive, logically it should go to the date when 29A. But let's leave that. Second, it goes back to 21st June when this action started. And third, it goes to 19 July when the petition was filed. There are only 3 possibilities, Malus. In all of these, the consequences would be that, Malus, actually everything, I would be guilty, but I am actually, by I mean people who have remained with Mr. Thackeray. I'm just using a phrase because there's no other phrase available, and people who have left. Now, the people who have followed the 10th schedule and remained with Mr. Thackeray would be actually liable for disqualification if your Lordship relates back that. So your Lordship would be giving a premium to those who follow the 10th schedule, and the people who have not followed the 10th schedule will protect their disqualification also and disqualify me also. Whereas your Lordships will not avoid the inevitable consequence by, of course, your Lordship's words can always, but that's the logical consequence of retroactivity. They would make an arc of immunity for their own disqualification and actually be liable because the party from 19th July, any whip, any order, everything, I have violated because I'm not the party from 19th July. And therefore, I am liable to something, or from actually, logically speaking, from the origin. Therefore, this... Huh? And it would have the strange effect of an election of Mr. Uddhav Thackeray in 2018. Would also go without there being a fresh election unseating him. Everything will go, No adjudication. By the mere act of recognition relating back either to 1990s or to 19th of July or to 23, 21st of June, there would be chaos. The consequences are, and apart from the fact that this is clearly textually not intended by the symbols order. The fourth and the last, under this head, I'm not on the next point, under this head, it would also destroy, not collateral damage, major direct damage. It would destroy the relating back which is held by a Lordship of Rajendra Rana. Now, note this, note this. Not a single judgment even of any High Court, leave aside Supreme Court, says that the Election Commission will relate back. A Constitution bench has held the field for very long, saying a disqualification 10th schedule order relates back. If your Lordship were today to do this, your Lordship would be giving primacy to an order under a symbols order, with any judicial precedent not saying so, versus a constitutional provision already held by a Constitution bench to relate back. And your Lordships cannot reconcile a relation back of disqualification with the relation back of the EC. It can't be reconciled. Today, suppose tomorrow the Speaker disqualifies Mr. ABC. It is common ground by Rajendra Rana and many other cases. It relates back to June 22. But there cannot be disqualification because by then your Lordship also would be applying a EC order retroactively. Therefore, your Lordship already has jurisprudence and a precedent.
Prospective according to you. All right.
Then, the fifth aspect is this political party and legislative party.
Dr. Singhvi, now 5 minutes now.
We will finish before Lordship's time. Within this time, we'll finish. We are conscious of that. 3:45 minutes, we'll finish within time. I'll give him 5 minutes also. He'll have 5 minutes. Now, F is a very important part. Actually, it goes to the root. This is the political party versus legislative party debate, but from an angle different than Mr. Sibbal's. This is very different. Kindly read this from a different perspective.
F, right?
Yes, F. Starting para 35, page 12. Well, as members of a legislature party do not have any right to act contrary to the directions of their political party. This is the heart of the political party legislative party debate, with which Mr. Well, call also started today at 2 o'clock. As per 194(1), the freedom of speech is subject to the provisions. I pointed it out already. Under 170(1), the assembly of a state consists of members. The members are elected by direct election from territorial constituencies, and the nature of the election process is such that an elected member set up by a political party has no independent identity in the House except as a member of the political party. Well, actually, in practice, how we sit, where we sit, which rooms we are given is all based on the collectivity of a party. Not an individual. Suppose a member is a leader of a party, he is very, very senior, but that party has only 3 seats. And another party with yesterday's first time member, but the party is a large number. Seats are allocated, rows are allocated, rooms are allocated only on the basis of party. That's the way it has to be. Now, prior to introduction, this is very, very important. Just kindly see this. This evolution has been forgotten in this argument of political party and legislative party. Prior to the 10th schedule, prior to 85, the constitution did not mention political party anywhere. Although in parliamentary democracy, the heart, as your lordship has in the English books, is political party. Westminster model is political party. Even though political parties were always recognized to be an essential component of the Westminster form of parliamentary government, political party as a term was defined for the purpose of election law in para 2H of the symbols order. Thereafter, through amendments, the ROPA, the Representation of People's Act, was put political party. They are the 2 statutory levels. It came in for the first time with the 10th schedule, which is a constitutional recognition of political parties. And today, a lordship has been asked to negate that recognition. Next para. On the other hand, the concept of a legislature party has no legal or statutory basis. A legislature party, by its very nature, is not a permanent association of persons. Its life is coterminous with the term of the House. The very coming into existence of a legislature party is dependent on a contingency, the success of more than one candidate belonging to a political party. The 10th schedule defines a legislature party in terms of a political party. That is conclusive, I say. According to me, I may be wrong. It's conclusive. Legislature party is defined in terms of the political party. I've quoted the definition. And your lordship is concerned with a whip. Whip is peculiarly a political party activity. I'm 41. The purpose of defining the group of members of the House belonging to one political party as a legislature party can be gathered from the number of times when legislature party is used. First, in 2.1, it says a member of a House belonging to any political party. What does it mean? Do you have an existence or identity other than the political party? After constitutional amendment and definition? Then, there is no mention of legislature party in para 2. None. In para 2, political party is mentioned. Thus, while referring to individual members, the 10th schedule refers to them as political party to which they belong and not relation to legislative party. The only place in the 10th schedule where the term legislature party is used was either para 3, now gone, or para 4. In para 3, the term legislature party was used when the fraction of 1/3 goes below. In para 4.2, it is for merger. Doesn't arise in this case. Doesn't arise in this case. Thus, wherever the 10th schedule provides protection to a group of legislators when acting as a group, it uses the term legislature party. Otherwise, it's described with reference to political party. Now, what is the consequence? This is a little important. The constitutional sequitur of this discussion is that a majority faction legislative party has no constitutional identity except for the purpose of setting up a defense under 4. This is important. Today, there is no status identity of a legislature party except for the defense of merger. That's all. And admittedly, that's not your case. If no defense is claimed, the legislature party has no constitutional or legal relevance, is para 43. Therefore, the group of legislators belonging to a political party can have no right of dissent or conscience. This dissent argument, dissent has to be within the parameters of what 10th schedule allows you. Dissent cannot say that's too broad a basis for your lordships to act or give any judgment on. Dissent, I just say I'm dissenting and I leave the 10th schedule. Reliance is placed on the law of speaker where Deho the Legislative Assembly disqualification rule, the president of the political party who was not a member was given the right to maintain disqualification. Well, this dissent point which your lordship put to me just now also, let me end on that. Just see Justice Venkat in Kyoto. That para has been read one sentence, but read the whole of it. This is directly the point raised in Kyoto. Your lordship will not be referring, Nawab Revil, or should be reconsidering Kyoto also on this basis. Now, kindly see. This is a very important para, para 49 at PDF page 109. 109. Very telling para, directly the same sentiment. How do you harmonize the two? And you cannot allow one to be reduced to vanishing point. Kindly see this. And I'll end in about a minute or 2 minutes. Indeed, in a sense, may I read this, fellows? 109. This is very, very important, fellows. It's a covered field. Your lordship need not be agonized about it, as my learned friend would like your lordships to raise a new issue before. It's a covered point.
1090.
109 PDF, CJ2?
CJ1.
CJ1.
Para 40.
Inappropriate acronym, fellows. We used to call it CL1, fellows. Case law 1. I don't know where this time. First time I found CJ1, fellows. Indeed, in a sense, an anti-defection law is a statutory variant of its moral principle and justification underlying the power of recall. What might justify a provision for recall would justify a provision for disqualification for defection. Now, kindly see the exact sentiment which my lords expressed to me. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful by the emotive political exaltations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. Can't be put better, fellows. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation, it's grotesque in 92, I don't know how much more grotesque it is now today, especially with the 4-step procedure here, whose awkward erosion and grotesque manifestations have been the bane of the times, above certain theoretical assumptions. Theoretical assumption. My learned friends have raised a theoretical argument, which in reality have fallen into a morass of personal and political degradation. We should, we think, defer to this legislative wisdom and perception. The choices in constitutional adjudications quite clearly indicate the need for such deference. Let the end be legitimate. Let it be within the scope of the Constitution, and by all means which are appropriate, which are adopted to that end. And here we have added, I have added 4 clear escape routes or mitigating circumstances. You don't follow them, but you follow this. This is extremely unfair. This is actually, this is again like that technique of giving a notice to the speaker. It is trying to decimate the entire 10th schedule by saying dissent. Dissent has to be within the boundaries of that. But I'm extremely grateful and
Thank you, Doctor.
very deeply obliged.
Thank you, Doctor. Yes, Mr. Kamat.
Lords, so I'll finish in 5 minutes, Lord. The 5 minutes left. Lords, I have put my thoughts in rejoinder in additional rejoinder A5, my Lord, which is just a 5-6 page document. I have just 5 submissions to make. The Lordships kindly have that. My Lords, I had addressed your Lordships on writ petition 479 of 2022, which was a challenge to the decision. Lord, that is A5. I'm sorry, my Lord.
Right.
It's rejoinder, additional rejoinder A5, filed yesterday.
Yes.
Yes, ma'am. My Lords, I had made submissions, my Lord, only on writ petition 479, which is challenging the validity of the decision of the Speaker on 3rd of July 2022. That is, my Lord, the change of recognition from Sunil Prabhu to Bharat Gogable late in the evening of 3rd July. Now, my Lords, the validity of this decision is, my Lords, unconnected with the ultimate, my Lords, view which your Lordships will take in the disqualification proceedings, whether your Lordships want to decide it here or send it back. This, my Lords, challenge is an independent challenge. Your Lordships will have to determine whether the Speaker was right or wrong. And the only defense which was taken originally in the reply was that it is 212. It is inside the house. And I had said that that is completely in the realm of unconstitutionality. There has been absolutely no rebuttal, my lord. That I have indicated in paragraph number 2, my lords, item 2. 3, my lords, I had submitted sub-Roman small 3, that the term political party is not an indeterminate, nebulous concept. Today, there are 30 people claiming, there may be more factions claiming that I am the political party. But on 21st of June, there was only one political party that was, my lord, in writing, which was communicated to the Election Commission, that was headed by us. Not with respect, this is not, my lord, a Narova Kunjarova. My lordships are aware of Mahabharat, my lord, that Ashwatthamo Hata, Narova Kunjarova. Whether they are Shiv Sena, we are Shiv Sena. In June, my lord, still they filed a petition on 19th of July. There was no dispute, there can't be any dispute in law that I represented the political party. So that's the second point which has not been answered as far as section 29A is concerned, my lord. Now, my lords, Mr. Sibal has pointed out about the validity of the whip, my lord, and that only the political party can issue a whip, and that Erskine and May, all that was cited. And my learned friends have argued that no, it's the legislature party can issue the whip, Rule 3.1, etc. The lordships have seen Rule 3.1. Rule 3.1 does not deal with a whip. Neither the form deals with a whip. That is by convention. And in fact, affirmed by your lordship's judgment in Mayawati. Kindly have the highlighted portion, my lord. Paragraph 73 of Mayawati, reproduced in paragraph 3 here. Whatever direction is issued by the leader of such legislature party must be regarded as a direction issued by the political party. This was the argument. There is no merit in this contention when the provision in the Constitution has taken care to make a distinction between the legislature party and the original political party and prescribe that the direction issued should be one issued by the political party or by any person or authority authorized in this behalf. There is no meaning in saying that whatever the leader of the legislature party directs must be regarded as that of the original political party. This is Mr. Kaul's argument, my lord, specifically rejected. Now, my lord, all this parliamentary convention which we have set out in paragraph 4, my lord, has not been rebutted. Not even one precedent shown, my lord. Now, my lords, kindly turn to Roman 3. And this is a legal submission, my lord, that having a legislative majority ipso facto or ipso jure is not suggestive of a majority in the political party. My lords, Roman 1 and 2 have already been dealt with. Now, my lords, kindly have Roman 3. In fact, my lord, there are one-member legislature parties. And in those, my lord, circumstances and facts, Election Commission has said that we have to see the organizational majority to see who's the political party. So therefore, my lords, merely saying that you are a legislative majority and therefore you represent the political party is legally incorrect. Now, my lords, reference was made to Sadiq Ali, that Sadiq Ali, my lords, affirms this proposition. In fact, in Sadiq Ali, my lord, this point was kept open, and I have highlighted that, my lord. Kindly have a look at Roman 4, the highlighted portion. The present is not a case where a conflict has arisen because of one group having majority in the organizational wing and the other having a majority in the legislative wing. This has fallen for consideration here. Now, my lords, one submission was made by Mr. Jethmalani yesterday that look here, we are also members of the Pratinidhi Sabha. Therefore, we represent the political party. Lords, on affidavits in the Election Commission and also here, for which there is no rebuttal, out of 220 Pratinidhi Sabha members, 160 plus, my lord, have supported me. 160 plus, not rebutted. Now, my lords, kindly see the next submission which is made. And this is again Mr. Jethmalani's submission, that Quixote said in paragraph 97 that the decision of the speaker is not covered by 212 and that the rules made under paragraph 8 have a constitutional status and therefore violation of that 2-day period or 7-day period is violation of the constitutional mandate. totally against Ravi Nayak, my lord. Not even one judgment was cited in support of that submission, but kindly see Ravi Nayak, it's covered. Now kindly see paragraph 8, my lord, the highlighted portion. The disqualification rules are procedural in nature, and any violation of the same would amount to an irregularity in procedure which is immune from judicial scrutiny. Then, my lords, I just have 30 seconds, my lord, I'll just finish, my lord. My lords, then a reference was made to some speeches, my lord, that I have dealt with. Lord, some speech of some DG is totally inadmissible. My lordships have held it time and again, which your lordships have seen in Kalpana Mehta Constitution Bench and also in Shivraj. Speeches by, my lords, members, totally irrelevant, my lord, to decide what the scope of the provision is. Yes, my lord. Then, my lord, para 6, they said that mere non-attendance of a meeting will not amount to a para 21A. Specifically, my lord, this was the issue in Shriman Balasaheb Patil. One meeting they didn't attend, it was held to be a para 21A, which I have reproduced, my lords, in paragraph 14. Now, my lord, the last thing is important. Kindly have paragraph 15. My lords, time and again, my learned friends, my lord, said that we have never claimed a split. In fact, I remember, my lord, Honorable Justice Kohli asking Mr. Kaul, is it your case that there is a split? And he said, on more than, my lords, 5 occasions, which I have reproduced, kindly see this. First, our case is not a split at all. I have never argued I have a split. Now, kindly see the submissions before the Election Commission. And now the cat is out of the bag. Please have a look at paragraph 16, my lord, of my note. And I've reproduced paragraph 7 of their petition before the Election Commission. In view of the above mentioned facts and circumstances, it is evident that there is a split in the Shiv Sena. And all the written submissions filed by Mr. Mahesh Jethmalani and Mr. Shinde, my lords, categorically say there is a split. I have pointed that out, my lords, in paragraph 17. To come here, my lords, and say that we are a faction, we represent the political party, is only sugarcoating, my lord, the factum of a split. Lords, lastly, my lord, ultimately your lordships will decide. Lords, I am reminded of a, my lords, Sanskrit Subhashit, my lord. And it says, my lord, Kakaha Krishnaha, Pikaha Krishnaha. That, my lord, the crow is also black, the cuckoo is also black. Ko Bedaha Pika Kakoye. What is the difference? Who's the Shiv Sena here? Vasanta Samaye Prapte, Kakaha Kakaha, Pikaha Pikaha. And I'm sure, my lords, the time of judgment will be clear, my lord, who's the real Shiv Sena. Thank you so much.
My lord, we'll be failing in our duty if I don't mention that the assisting counsels, my lords, on both the sides did a phenomenal job in assisting us. And very grateful to your lordships for all the time.
Our compliments to you for
Yes.
Yes, my lord. Rohit Sharma is yes.
our compliments
All on the sides, my lords, they did a phenomenal job. We could not have argued this without their
to
assistance.
the juniors as also
Yes.
to
We are
Very
grateful
grateful, my
very
lords, for all the
patient
time that your lordships gave us, for all the time that your lordships.
we'll
Grateful,
reserve judgment.
grateful.
Very, very grateful.